Thank you. Thank you both. Melcher versus Greenberg, Traurig.
Huh?
That's it, you have to come on.
That's it?
That's it, yeah, next case. That's it, it's finished, yes, time's up.
Your Honor, excuse me.
Sir,
There'll be a decision on the case, and
Last one I did you say,
we have your papers and we have your brief. We will study it very carefully.
We will study the papers very carefully, okay? What you submitted, we have copies of.
Thank you.
May 6, I did told you.
The argument is finished.
okay, sir, go step this way.
Are you too? Well,
Just come right up.
okay.
May it please the court, I'm Jeffrey Jannuzzo. I represent the plaintiff appellant James Melcher. First of all, thank you for granting us oral argument. Before I start on this 2018 appeal, I want to welcome Judge Tom and Judge Friedman back to the case. You sat on the 2008 appeal where the defendants were given the right to a trial, which they never used. On this 2018 appeal, our position...
Lupkin has two theories of recovery. Is that correct?
Yes, Your Honor.
Are you on appeal pursuing both of those theories?
Essentially, the court below just struck the report, and so what I'm really doing is arguing that the court used the wrong standard, and that it created a standard which is not what should be applied here. We showed now, without any real opposition from the other side, that for a statutory violation case like this,
But do you contend that you should be permitted to pursue both of Lupkin's theories at trial?
Your Honor, I don't want to give it up, but the first
But it's the first theory
it's
that
the
you're
first
really-
one is our real theory.
That's
The
what
real
you're
theory is,
interested in.
what Lupkin laid out was a series of timelines, where if the jury found that as of that time, the defendants committed intentional deceit about a material and central issue, that the costs going forward were as set forth in his report. And really, that's our principal theory. His second theory was to act as a comparison to the first, and so what I'm really here arguing for is his right to present the first under the standard of Daggett and the other special statutory cases, which is some reasonable or practical connection to the damages. There's only 4 laws like that. One is the explosives law that was in Daggett, which this court used as early as recently as...
Isn't the standard proximate?
The Daggett line of cases for the dram shop, the firefighters, this law and the explosive law does not use proximate cause. In fact, it says in so many words in all of those cases that proximate cause in the sense of a negligence case
Didn't
is
we
not
make
required.
clear in our prior decision that the plaintiff may only recover legal expenses as a proximate result
No, Your Honor.
of the material misrepresentations made by defendants?
That's what the defendants contend, Your Honor. It's not true. What the court did, that case concerned a procedural issue, which was whether you could bring the case in a separate action or in the same action, and held for us that it was proper to bring it in a separate action. There were 2 sentences in that decision, at page 500 and 554 of the decision, which paraphrased Mr. Melcher's allegations and did nothing more than that. There was no holding. It wasn't even before the court. There was no issue before the court in that case.
You're saying it's dicta at best.
It's not even dicta, it's background. The court said in the first quote, Melcher further alleged that as a result of defendant's actions, he incurred damages from excess legal fees to be troubled. So that's all it says. It's background saying what Melcher alleged in the complaint. So the court below got that wrong. It misconstrued something which is not even dicta as being a binding rule. And in preparation for the appeal, I actually found there's a pattern jury instruction for these special laws. It's called the special statutory actions. It covers the Dram Shop Act, it covers the explosives, it covers the firefighters law, and it's PJI 2:28. I didn't know that until I got second opinion counsel for this appeal, He was a former Court of Appeals clerk, and he picked it up right away. So this will be the first case of damages that goes to trial in the modern era of this statute. The modern era begins in 2009 with the Amalfitano case. We have had the unfortunate pleasure of making law at every stage of this case, from the 2013 appeal that wound up in 2014 in the Court of Appeals with common law reception as establishing the 6-year statute, from the 2016 appeal that established the procedural question. We will go to trial, I hope, with the proper legal standard, and I hope the jury will be allowed to make the decision of how to apply that after they've heard all the trial evidence, which will show a fraud on the court as appalling, or at least as appalling, if not more so, than the one that Judge Tom called out in CDR Crayons in 2012.
Thank you.
Good afternoon. May it please the court. I'm Tom Rice, and I represent the defendants, respondents here. As your honors heard, the plaintiff's entire appeal is based on the notion that proximate cause is not the right standard for damages under a Section 487 case. That couldn't be more wrong. It couldn't be more frivolous an argument. Your Honor was absolutely right that in the 2016 decision, on a page that counsel didn't refer to, this court, its law of this case, laid out the elements for a Section 487 case, and it said further, the plaintiff in a Section 487 case may recover the legal expense incurred as a proximate result of the material of misrepresentation of fact or law. That wasn't the first time this court or other courts in this state have spoken on proximate cause. We cited the Doscher case, the Feldman case, the Stromwasser case. Justice Tom, you were on the panel in every single one of those cases, and Justice Mazzarelli, you were on the panel in one of those cases. And in each of those cases, the court not only found that proximate cause was an element, but it granted dismissal on motions to dismiss where proximate cause wasn't pled. It granted summary judgment where there wasn't evidence of proximate cause. And those aren't the only cases. There are lots of others. Justice Mazzarelli was on the Zimmerman case where the court found, this was a case against O'Melveny and Myers relating to the polyprep scandal. And what the court found there was because the plaintiff in that case was a contingency firm, and when the plaintiff alleged its damages was it had to do extra work because of the deceit, the panel found there couldn't be proximate cause because the plaintiff was going to pay the same amount no matter what. It's absolutely clear that proximate cause is an essential element of the claim.
Let's assume for
Yes,
argument's
Judge.
sake that causation is an issue here. What about with respect to Mr. Lupkin's first theory, looking for legal fees going forward from when defendants became aware that the amendment was fabricated?
Right.
Would a jury make a causation connection between on that theory?
Absolutely not, Your Honor, because there are large swaths of the case. So if let's assume arguendo, my clients concluded, right, that the document was a false document, what the clients had to do under the disciplinary rules at that time was not rely on it, but they could go forward and defend the case on any other basis. That's what they did here. The trial of this case, which happened after any of the alleged points of knowledge, this case was tried on the basis of oral agreement and on the basis of estoppel and waiver. All of those fees have nothing to do with the deceit in the case. So all the trial judge in this case said, and remember, this is a trial judge who's had this case a long time, he knows what case is about, is he said, he didn't say you're out of luck on damages, he said, Mr. Lupkin has to come back, and he gave them a chance to do that expressly, and take a look at what happened in the case and say what damages were, what legal fees were caused by the deceit here. Certainly there were some. Justice Sherwood has recognized that. There was litigation, right, over whether or not the document was real. That kind of stuff are the kinds of damages that were approximately caused. But because the case was commenced based on a written contract, which isn't in dispute, because it dealt with a number of other issues as well, questions of diversions of funds.
Well, couldn't those be arguments made before the jury? Because you will acknowledge, won't you, that classically we say that juries should make decisions with respect to whether or not there is proximate.
Right, fair question, Your Honor. But the answer to that is that the trial judge has the obligation, and this is what a trial judge should do in limine motions, is to not allow inadmissible, irrelevant, or prejudicial evidence. Just as Tom wrote in a case called Guzman that we cited in our papers, that duty is to be a gatekeeper, to basically, number one, deal with the qualifications of experts, but number two, to say, is there an evidentiary basis for the opinions? In that case, there was a question, there was an expert who said, well, the plaintiff suffered from traumatic brain injury, but he couldn't tie it or didn't tie it to the accident. What the court did in that case, and what Justice Tom wrote was absolutely proper, and this court found was proper, was to say that expert opinion doesn't come in, but I'm going to give the plaintiff a chance to come back with a new expert or the same expert and see if you can make that causal tie. Without that, all you're doing is letting the plaintiff throw up big numbers in the hope that it will prejudice the jury against my clients. Now, we are completely prepared at the trial that we're looking forward to in this case to proving that there was absolutely no deceit, but we're also entitled, Your Honor, to only have to face expert evidence that is admissible. In this case, it's just not.
Thank you.
Thank you.
On rebuttal, the simple fact is that in those proximate cause cases, as we showed in the reply, there were no damages at all. The first, and so they don't really stand for anything as such. The fact that the court used a shorthand phrase, proximate cause, is not an indication that it was ruling on, that it was denying the right, the statutory action under Daggett. We will show that we had an appalling fraud on the court, and they talk about how that's not a factor, because there were other things. As Justice Tom said, once you get caught in a fraud on the court, that's the end. You don't get to say never mind. So we'll show that from the beginning. But let me read the language from Daggett, which, we're the first people to bring it forward, just like we were the first people to bring forward the doctrine of common law reception. The statute had been around for 200 years, and no one thought of reception of common law until we did here. And that's established.
But tie it into the question I asked previously with respect to Lupkin's first theory, assuming that causation is a standard, is that something that the jury should decide?
Yes, the jury should decide it under the standard of Daggett, which is that injury sustained as a result of the violation of the statute imposes liability so long as there is a recognizably practical or reasonable connection between the violation of the statute and the accident which occurred.
And what's the connection in this case?
Yes, the connection
What
is
is
that the phony amendment and the cover-up about the amendment, meaning the lies about a witness in Vermont who couldn't be contacted, the statement to this court that they hadn't learned the result of the ink test until 5 days after their client signed the affidavit. Judge Tom and Judge Friedman were on that appeal. All of those things are connected, poisoned the entire case. And in fact, our only claims for money damages were directly related to the amendment. As Judge Richter said in the 2013 Apollo decision, the amendment was the central issue in the case, and if it was genuine, it was dispositive against Mr. Melcher. You can't get more central than that. And so, the things like intervening events are expressly excluded under the Daggett reasonable connection standard. That there are other elements in the case are expressly excluded under the Daggett standard. It happens to be that we're the first people to bring it forward to a court, and that makes it all the more important that the decision comes out right, because this will be the first jury trial in the modern era of Section 487.
Thank you. Thank you both.
Thank you.